welcome back. I hear that there's a new public charge rule that's just come out. If you could enlighten us a little bit about that.
Yeah, sure, Vijay. And actually, for those folks who are tuned in, who tune into some of our prior programs, they're aware that we've discussed the basis of inadmissibility for public charge, which I believe we discussed in the context of the I-864 Affidavit of Support, which is a document that needs to be submitted with all family-based immigration procedures. And for those folks who might be aware and who might be following this, the Trump administration had made very significant proposed changes, which were only policy changes and guidelines that were put forth by the administration at the time that basically made it difficult for individuals to get the green card who were relying upon certain types of cash and non-cash benefits. So if individuals took advantage of either cash or non-cash benefits, they would be potentially barred from being able to apply for adjustment of status and getting their green cards. So actually what happened was the Biden administration on day one, of course, took to task the former administration's position on the affidavit of support and on the public charge rules. And it took them a while, but finally yesterday we had a final rule. It was published in the Federal Register yesterday. And what ended up happening is that we went back now to the historical definition of public charge, which goes back to the 1999 definition of public charge. And so now, if an individual has taken advantage of, let's say, Medicare, Medicaid, or food stamps, it doesn't mean that it's going to be a bar to their ability to be able to get the green card. Mm-hmm. So specifically, the new rule explicitly states that immigration officers won't consider an applicant's use of Medicaid, housing vouchers, or aid allocated during emergency circumstances as a basis to bar adjustment of status in the United States. And you know, Vijaya, that's super important, especially given what the heck has been happening in the United States over the and in the world with the pandemic, you know, over the last several years, because COVID-19 has really thrust a tremendous burden upon people when they've had to go for emergency care. And so at least that emergency care during the COVID-19 pandemic will not act as a bar to their being able to adjust to lawful permanent residence. So this is really good news. It's nice to be able to go back to the former historical definition of public charge, which made things a lot easier. It sort of takes away that subjective element that was infused into the system by the Trump administration. So, so we were very happy to hear that.
So that's a big relief,
Big relief, big relief, for sure.
And also you're planning to go to India with the NPZ law team, so that's a great.
That's right. We're getting our plans together. We're trying to decide, our dates, but we're obviously going to let everyone know when we go. We go to the consulate offices in India, in New Delhi, in Chennai, in Mumbai, and we talk to the consular officers and we find out about their policies, and we find out, obviously, we haven't been there for the last 3 years, so it's going to be great to have an opportunity to update ourselves.